Okay, hello, how are you? Hope you're well. Now, today we are going to be looking at arbitration, and arbitration is one of the mechanism of ADR, this alternative dispute resolution. My name, for those who are interfacing with me for the first time, I am Geoffrey Mtale, and I'm a court accredited ADR practitioner. So today I want to take you through some of the mechanisms practiced in ADR where we can resolve disputes outside court. We understand the process of litigation in court. One takes a lot of time and could be very expensive. So to reduce on the case backlogs, it is always preferred that some cases are actually resolved outside court through the different alternative dispute resolution methods or mechanisms, and the arbitration is one of them that I want actually us to be going through today. So for those who want to contact me, below on the timeline there you can see my telephone number, just in case you need to reach out to me for any assistance as regards ADR. So what do we expect out of this presentation? So one, we shall define what arbitration is, and then we shall look at the scope where we can apply arbitration as one of the mechanisms for resolving conflicts. We shall look at the different types of arbitration. We shall look also at the key features of arbitration. Then we also are going to look at the legal framework, specifically in our country, Uganda, for those who are watching from a different country, specifically from Uganda, and we shall be discussing the legal framework and admissibility, specifically in the country where the laws of the land apply, specifically for this case is Uganda. And then we shall also look at the arbitration process, how we go through the process of identifying the arbitrator, identifying the case, getting the merits of the disputes, and then how to resolve them. We shall look at the merits and demerits of the arbitration process, and then we shall also look at the arbitration agreement and the challenge, how it is written, and the challenges which may come along with arbitration. So in brief, defining arbitration, we may define arbitration as a form of ADR. We said ADR, stands for Alternative Dispute Resolution, which is a process where disputes between parties are resolved upon agreement to submit their conflict to one or more impartial arbitrators. So to have an arbitration take place, we must have an arbitrator. So this may be one or a group of arbitrators, but this must be agreed upon by the parties involved in the dispute. And this arbitrator must be, this is very key, must be impartial. They shouldn't have conflict of interest in the matter, and you need to practice your impartiality to the best that you can. So the arbitrator here will listen or will hear the evidence that will be presented, and then review the arguments, collect the relevant facts and information, and make a decision which will be known as an award. And this can be binding or non-binding, and this will particularly be dependent on the parties' agreement. But one key point that you need to take here, the take-home point here, is that in arbitration, the decision which is finally made may be binding and may be endorsed by court. This is for as long as the two disputing parties, agree to what has been decided. If it is ruled, if the award is given, it is binding. Unless if the parties do not agree, or one of the parties does not agree, and then the party may appeal, or they may not actually append their signatures and agree with the conclusion or the decision made by the arbitrator, and in that case it may not be binding. So what are the different types of arbitration that we have? We have commercial arbitrations, and these are specifically to deal with business-related disputes. We also have international arbitrations, which are cross-border between different states, like for Uganda and Congo, Uganda or another country, and these are also business-related, commercial-related. And then we also have labor arbitrations, where we have the employer-employee conflicts, and this may relate to employment agreement, salaries, and something of the sort. We also have investment arbitration. This could be between the investors and then the state. And also we can have the ad hoc versus institutional arbitrations, and this specifically makes a comparison of the two frameworks to see which one is best admissible. Now, looking at the key features of arbitration, one, the arbitration process could be either voluntary when two parties choose to have an arbitrator, or it could be mandatory when it is decided either by court that these parties have to go for arbitration. So it could either be voluntary when the two conflicting or disputing parties agree to find an arbitrator, they make an agreement, or they may be compelled by legal provisions, like when it comes to mandatory. But in most cases, it should be voluntary when the two conflicting parties agree to have an arbitrator. Number two, in arbitration, like I noted in the beginning, he said the awards made, the decisions made by arbitrator, they are binding, or they may not actually be binding. So for this case, in a binding arbitration, the arbitrator will make a decision which is final and is legally enforceable with limited grounds for appeal. And then in the non-binding arbitration, you find that the decision here serves as a recommendation, and the parties retain the right to pursue either the legal remedies if unsatisfied. The parties in the non-binding may have their rights to appeal the decision made or by the arbitrator and seek legal remedies in the courts of law. So those are some of the features. And then we look at the process of selection of the arbitrators. So like I mentioned, parties typically select the arbitrators with relevant expertise. So the arbitration panels can consist of either a single arbitrator or multiple arbitrators, depending on the choice of the disputing parties, because all what is intended to be is that there is fair judgment and there is contentment between the two disputing parties, that whatever shall be determined at the end of it all will be acceptable, will be enforceable, everywhere. And then another key feature that we shouldn't forget is confidentiality. Because in arbitration, there are some things that the disputing parties may reveal privately to the arbitrator for purposes of sorting the matters out, which may actually not be said out during litigation processes in court. So, for such information, for such private information which is shared by the disputing party, either during caucusing, when you caucus with these parties, and then they come up to trust you and reveal some special secret information. Somebody may be, there could be a dispute, sincerely, and this person knows the fact is the check I issued, there was no money in as much as I issued this check, but there was no money at the account. So the reason for bouncing the account is not that the signature was wrong, but the fact is I did it just to avert something, but there was no money in the account. So such information, if it is said to you privately, you should keep that information confidential. You shouldn't go speaking everything out. You should not go into the public, but it should be confidential for you, and it will help you to guide and to make your decision at the end of it. And another feature is flexibility. When we meet and we choose to arbitrate, when we meet these parties in a place which is selected outside the court spaces, there's a lot of flexibility. In this, we agree on how the process can be facilitated. The process is actually tailored to the needs of the parties, offering more flexibility compared to the rigged court processes. At least here you can sit, agree as on when and how to meet at what time, not like when it is in court, when you're given orders and instructions of when to come and when not to come. But here you agree on the modalities and how you're going to take through your process of arbitration. So let's look at the different stages of arbitration. And here in the arbitration process, we have to have the arbitration clause in the agreements we made. Like I said, or like we saw earlier on, that arbitration in most cases will appear in business related disputes. So in most cases, in business related disputes where people make partnerships or agreement to work together in different companies, there must always be a clause in the agreement which states clearly that in case of misunderstandings, in case of discontentment, in case of abuse, in case of breach of the contract, then the parties involved in the agreement must seek arbitration, or the arbitration process should be clear. So here the first step is there must be a statement, there must be a clause in the agreement that the matter will be arbitrated and how the arbitration will take place. And after that, an arbitration notice must be issued after identifying and confirming that in your agreement you have the clause to do with the arbitration. Then the disputing parties, actually the person claiming or putting up a claim, must actually issue a note of arbitration to the partner, and it must be received. And when a notice is given, the next thing to do is to appoint an arbitrator. So after appointing an arbitrator that both parties are comfortable with, or appointing arbitrators for that case, because we said in an arbitration process you can either have one arbitrator or you can have more than one arbitrator. So after identifying and appointing and coming up with an arbitrator that you feel very comfortable with, then we have now to listen to the statements of the claim. This is where now the arbitrator comes, the two parties come in place, and then they present their cases. The claim is listened to, and then what happens next? We have hearing of both parties. You share your side, and then the other person also shares the side. And as an arbitrator, you listen critically, pointing out and identifying factors, identifying key issues, identifying the merits of the claim. And in this process, as an arbitrator, you are in a position sometimes to advise on either the jurisdiction of the matter, whether it can be handled in the arbitration process. You listen to the evidence sometimes which is provided to assess whether it is admissible or is not admissible. You are in a position to guide the two parties to see whether whatever the dispute being handled is actually in the right hands, and it can result in conclusions which can benefit both parties. So after listening and assessing to the different claims of different parties, listening to the presentations, collecting the evidences, looking at the facts on ground, and any other matter, any other substance that may help you to make a ruling, to make an award, to make a conclusion on the subject matter, then you go ahead and make an award in writing. So after making an award, these two parties must all agree and accept the award or the conclusion that is made by you. And after it is made, the last step is to ensure that the award is implemented, or you ensure the execution of the award. This may not be in totality in the powers of an arbitrator, but in some circumstances this can be enforced by court, because like we said, an arbitration award which is made is enforceable and may not be challenged. So in cases where enforcement is needed, it may be sought from court, and you as an arbitrator, you may simply follow up to see whether it is enforced, and maybe try to talk to the varying party, to the disputing parties, to honor the award and do it. Just make a follow up. But as an arbitrator, you have no powers to enforce. You can seek authority from the court, you can seek help, assistance, or from any other authority like police to enforce the award. So, still looking through at the arbitration process, we said there must be an agreement to arbitrate. We identify that in our agreements made during our drawing and coming up with our contractual agreements. There must be a clause or an agreement to arbitrate. And then number two, we have the selection of the arbitrator. We went through this. Then we have the preliminary hearing. We have established rules, the timelines, and then the procedure guidelines on how this is going to be made. Then we have submissions of the evidence and hearings. So we have parties which will have to present and maybe witnesses if they are available. We'll look at the testimonies, and then we put up legal arguments, and all these arguments must be admissible. Even the evidence should be admissible, and how it is going to be presented should also be evaluated. As an arbitrator, you must be in a position to evaluate this, because somebody cannot come and is going to adduce evidence before you of how the rape happened, and somebody is going to undress himself or herself to try to demonstrate. No. So you must look at how the evidence is going to be presented. So what happens next? There is deliberation and then award. You discuss. The arbitrator deliberates and issues a decision which is binding. The arbitration award is binding and is final and is enforceable. So after all the presentation and listening to all what the varying parties have submitted, you basically have now to make a conclusion and give an award. And then, like we said, the last bit of it is enforceability. So given the nature of the award that is binding, this can be enforced through courts if necessary, and where it is not binding, the awards do not have to be enforced because they are not legally enforceable. So what are the advantages of having an arbitration compared to going through the litigation process in court? Number one, it is quick. The speed is generally good enough. It is speedy. It saves a lot of time, and people can go through this very fast compared to court cases which can spend a lot of time, years in court. But this can be solved in a quick and short time. And then we look at the cost effectiveness. So we look at this, that in as much as this is taken to be a cheaper process, it may depend on the nature of arbitration, because you may find that some arbitration cases may actually be more expensive than the litigation process, depending on the nature of the dispute. If it is a cross-border dispute, you may find that it may cost a lot in arbitrating such matters compared possibly to the court processes. And then we look at the matter of expertise. Here, parties can select arbitrators with specific expertise which are relevant to their dispute, which leads to a more informed decision making, and the decision made in most cases is universally accepted, because the two parties participated in choosing who the arbitrator can be compared to when it happens in court, when they have no choice sometimes of selecting who the judge to make a ruling on their case is. And then the next point, we look at the finality, and in this case we say that the awards made are binding, and this will provide a conclusive resolution, minimizing the likelihood of prolonged disputes in courts of appealing and reappealing in that case. And then we also have points of confidentiality, and this, it gives the disputing parties at least room to express themselves with the fact that it will be confidential, compared to some cases where we see in court and the number of people and someone has to present a case. Sometimes it becomes hard even to adduce some specific evidences for cases of privacy and confidentiality, because not everything has to be spoken. But in this case, where you have a one-on-one, somebody can feel very comfortable to speak and reveal the secret that she may not be actually very comfortable to speak in the public. And then we look at flexibility. So the procedure rules can also be customized to suit the needs of the parties, unlike the proceedings in court. Like I said, here the two parties may sit and agree, depending on the nature of their timetable. If they have work, I say, no, we can meet on a Saturday. Yet it is very hard, even on a Sunday, or even on a public holiday, depending on how these two parties agree, which cannot be very easy in courts of law, because for them they say it their own date and you must follow whatever the court says. So what are the disadvantages? The disadvantages that here we have limited discovery. So in arbitration, it may offer limited opportunities for evidence gathering compared to litigation. And this may potentially be a disadvantage to some parties. Like, for example, if some disputes need really thorough investigations, they need some evidence to be adduced, and maybe these evidence are electronic, they need a forensic investigator. This may not be possible with the arbitrator. They may need a lot of money or a lot of investigation and discoveries to unearth more facts. So this may be a disadvantage, because in arbitration there may not be time or that expertise to get into that. And then cost concerns, we also understand that in the complex cases, arbitration can also become very costly, just like litigation, or even more than litigation. Actually, in cases which may even involve high arbitration fees, depending on the nature of the dispute being handled. So another disadvantage is that we have limited options for appeal, because we said that in arbitration the conclusion made is always binding. So because of the binding nature of the arbitration decision, this offers limited chances for appeal, because the decision is always made binding. And then the next point is there could be potential for the arbitrator bias. If not carefully selected, arbitrators may actually favor one party or the other. So that's another disadvantage, most especially when possibly these arbitrators have some conflict of interest in the matter. They may end up being biased. And then there's lack of transparency. Confidentiality can lead to lack of public accountability, which might be a concern in matters of public interest. You remember here we said we must be at least as confidential as we can, because some of the information that may be revealed to us could be a little bit confidential. Like, for example, somebody could have possibly defiled somebody, kept his information confidential, and then reveals it to you. But the good thing, like for such cases, for such criminal matters, in most cases they are non-arbitral. They don't come to us, the arbitrators. No. For criminal matters, most of the time they are handled by court. Those criminal matters which attract sentences always handled by court, they don't come to us to arbitrate upon. We shall, in our subsequent slides, look at the nature of cases which are arbitrable, and then we'll also look at the nature of cases which we do not arbitrate actually. But I'm just giving an example. So for the public interest, some information may not be actually given out because we need to keep the confidentiality point of it. So where do we apply the arbitration? Like we said, this is applied in commercial disputes. It can be applied in employment disputes. It can be also applied in international disputes and also in consumer disputes. It can as well be applied in intellectual property disputes. It can as well be applied in energy and natural resource disputes and many others. Like banking and finance, insurance, real estate, and then it can also be applied in maritime and shipping disputes. In a nutshell, most of the time, arbitration always happens in commercial disputes. In disputes involving earnings, somebody feels cheated. When somebody feels cheated, somebody is not paid, the payment is delayed, a business has done to kick off, the construction has not yet started. In such cases which involve monetary value, in most cases, that's where we always apply arbitration. In sports and entertainment, healthcare and pharmaceutical disputes, where you find disputes which are over service agreements, and these are all relate to with the financial factor. So, what are the common grounds for arbitration in such? So, the grounds we have for arbitration is when we realize that there is a breach of agreement, when the parties made their agreement and the one party has breached the agreement and not fulfilled, when there is the interpretation of contract terms which are not clear, we may come to agree and then arbitrate upon the different terms which are not actually interpreted well. Yeah, arbitration may arise as a result of performance issues. Somebody was given work to do, but the way they are performing is not as according to the agreement made. So a dispute may arise, and we may come in to dispute and then make awards in such disputes. We have claims of damage and losses. Somebody has lost something and wants to be compensated. Arbitration can come in, and then we see how this can be resolved. So we also look at the non-arbitral disputes, and these non-arbitral disputes may involve like the criminal disputes, like I mentioned before, which may involve crimes like theft, assault, fraud, human trafficking, the homicide. These are criminal cases which cannot actually come to in arbitration. We have family matters, and these family matters which may be involving divorce, child custody, specifically these ones we don't handle, and specifically in Uganda, in the jurisdiction, like in Uganda, these ones are not actually acceptable. These are specifically handled by the courts of law. We have domestic violence and abuse. These ones are also not arbitral disputes. We have public law disputes. These ones are also not arbitral disputes. We have personal injury claims, cases like motor vehicle accident, working injuries, especially where government tort law rather than the contractual obligation is involved. These ones are also not arbitral laws. Disputes. We have environmental disputes like pollution of the environment, damages in the environment. These may not come to our platforms for arbitration. We have the public interest litigations. Also, these ones are not arbitral cases. We have disputes like the probate and estate disputes. These are also do not fall under the arbitral disputes. Then we have the corporate law disputes. Also, these ones are also not arbitral disputes. So, what are the roles of an arbitrator. I encourage you to read more about some of the presentations I'm making. I may not be very exhaustive, one, because of time, so I may not have enough time to exhaust everything. But as I present, I believe you're taking notes, and this is going to help you to read further and understand this more. So what are the roles of an arbitrator? So an arbitrator, one, the arbitrator will have to ensure that there is impartiality and independence. So the arbitrator must be neutral and impartial, meaning that they should have no bias or interest in the outcome of the dispute. You should be completely neutral. The moment you have interest in the outcome of the dispute, this may actually affect your judgment at the end, because you may not give a fair judgment for that case. So they must disclose any potential conflicts of interest in relationship to any of the parties involved, if any. If these parties, in as much as they have appointed you as their arbitrator, but when you realize that you have some conflicts of interest, either you could be a brother to one of the disputing parties, you could be a relative, you could have been a boyfriend, a girlfriend, you could have been possibly a teacher, and there are things that you feel cannot put you in a position to make a neutral decision. Please declare and excuse yourself. Let these people have another arbitrator who can make the ruling with neutrality, because that's one of the key values that we need to have as arbitrators. Number two, the arbitrator must manage the arbitration process, and in this case, we expect the arbitrator to be knowledgeable about the entire process of arbitration, be knowledgeable in the law, because you're not going to use your own wisdom to make judgments and to make rulings, but you must follow the law. That is the awards which are made under the law that will be enforceable and acceptable by court, and even accepted by the parties. So, as an arbitrator, you must be knowledgeable, you schedule the hearings, you must be also keen with the procedural aspects of the matters, such as the exchange of evidence, the witness testimonies, and the legal arguments. They must be within the law. Ensure that the proceedings are conducted efficiently and in accordance with the agreed upon rules of procedure. We shouldn't reach anywhere and then you forget what we agreed upon. No, we should follow what we agreed upon in the pre-mediation meeting. So what else does the mediator do? The arbitrator must be in position to make a ruling on procedural issues. So decisions of jurisdiction must be considered. The arbitrator decides whether the dispute falls within the scope of the arbitration agreement and whether they have the authority to hear such a case. Because I'm just imagining, if you have been appointed and these two parties have their dispute, they want to divorce, and then they are calling you as an arbitrator to arbitrate such a matter. The arbitrator must be in a position to know on the jurisdiction of the matter, to be able to tell whether the conflict brought to them is within their powers to handle. Next, the arbitrator must be in a position to make interim orders, because in certain cases, the arbitrator might issue interim orders, such as restricting orders or orders to preserve evidence to ensure that the dispute does not cause further harm or prejudice to the parties. So irrespective of how these people are claiming to have evidence, you must be in a position to judge. So this person wants to bring this evidence, but if it is brought, what impact is it going to have? You remember we talked about the issue of confidentiality. So we are not getting into the arbitration process to expedite the situation, but we are looking at how we can solve without causing more harm. So this calls for wisdom as you are arbitrating. Yes, even though there is evidence which is produced, you must be keen to look. That's why it is always important to have pre-arbitration meeting, to do caucusing, meeting possibly with these people separately, with the disputing parties, so that we can listen from them. Possibly you can even try to inquire which kind of evidences these people have, and you could be in position to guide on which evidence should be produced and which evidence may not be produced, so that we do not worsen the situation, because we are looking at solving the matter. As an arbitrator, you must be in a position to adjudicate on evidence and witness. So the arbitrator must be in a position to decide what evidence is admissible and how witness will be presented, ensuring that the parties have an equal opportunity to present the case. So both parties must have a chance to present, but in a fair manner. Okay, so the arbitrator still must be in position to facilitate settlement by encouraging settlement. In some cases, the arbitrator may encourage the parties to settle the dispute amicably through negotiation or mediation. However, this may not require, and this is not a requirement and depends on the nature of the arbitration. When, in as much as you go to arbitrate, and at the end of it all, as an arbitrator, you have to make an award. But looking at the nature of the dispute, you may choose to take a different ADR mechanism, because arbitrating at the end and making an award, one party may not be happy with whatever may come out, because this is a ruling, this is a judgment almost, which is going to be made and is enforceable. And in most cases, when it is enforceable, it has an impact on somebody against which the ruling has been made. So if you find an opportunity of having these two disputing parties coming together and negotiating to solve the matters amicably, instead of making a ruling against the other, would be a better. So the arbitrator, you must be in a position to facilitate settlement. You must be able to mediate these two parties and make sure they come at a mutual conclusion of the matter. And then we also must be in a position to apply the law. Like I said, you must be knowledgeable. Any ruling, any award, any judgment, any decision that you make must be within the law. You don't just make the awards, because if you make awards which are outside the law, which are not enforceable, which are not acceptable, they cannot be enforced. And parties they can refuse to accept your awards, to accept your decisions, and they may not be even enforceable by the courts of law. They may be rejected, and the process of mediation may have just wasted time, and this may end up getting back to court for to seek remedies in court processes. So you must be knowledgeable. So you must be in a position to render an award. So decision making is very important. And after hearing the evidence and looking at all the facts which have been presented before you, and looking at the nature of the disputes, the decision has to be made. And this is called an arbitral award, and is typically binding on parties the moment it is reached on and all parties agree. So awarding remedies, the arbitrator can award various remedies, including damages, specific performances, or other forms of relief as appropriate to the case. It shouldn't be like what we saw in one of the courts in Uganda here, and that's the Military General Court Martial, where one of the lawyers was sentenced to 9 months, which was against the Penal Code Act in Uganda. So the sentence was an outlaw itself. It was out it is not enforceable for that matter, because according to the General Court Martial, according to the General Court Martial's ruling, the attorney was sentenced to 9 months, but what is in the Penal Code Act, he was actually to be sentenced for a period of not less than, or a period of not more than 30 days. So that cannot be enforced in a country or in a region where there is a proper adherence to the law and the rule of law. That cannot be enforceable. So when you're making these awards and other rulings and then awarding the remedies, you must make sure that they are enforceable. You shouldn't do anything which is outside the law. So the award should be reasonable enough. You shouldn't give awards which can not be manageable, which cannot be, which are not practical, which are not possible, which cannot be enforced. So it should be within your wisdom, because you must do this with a lot of neutrality, knowing you're being neutral, you're doing the right thing, and within the confines of the law. So you must ensure that there is fairness and due process. So the arbitrator must ensure that both parties have the opportunities to present their cases and submit the different and relevant evidences. So the process should also be conducted in a way that upholds the principles of neutral justice, meaning that the decisions are made based on the procedure and both parties are treated equally without favoring the other. We talked about confidentiality. All the awards made must be confidential, because these people have decided to come to you as an arbitrator. They have left the court public place, they have come to you. So whatever is made during the arbitration process must be kept confidential. So enforcing the award. So while the arbitrator does not have the powers to enforce the award directly, their role is to make sure the award is clear and capable of being enforced. If the losing party does not comply with the award voluntarily, then the prevailing party may seek enforcement through the court system, depending on the jurisdiction and where the arbitration was made, whether it was international or it was a local one. So when you're making your award, you must make sure and consider the enforceability of the award that you're given. And then you also must be considerate about the appeal and then challenges. So the arbitrator's role generally ends once the award is rendered. However, if parties wish to challenge the award, they may do so in a court on very limited grounds. Like, for example, if the procedure or if the procedural fairness or jurisdictional issues were not actually made. If one party feels that the procedure was not actually made, or the case which was actually arbitrated did not fall in the jurisdiction, it was not arbitral, so the parties, the affected party may choose to appeal, and appeal can be actually taken up by court, and a ruling may be further made by court against the decision or the award made by the arbitrator. So the arbitrator may be called upon in court to explain the aspect of the award requested by court. So an arbitrator's role is multifaceted, which may involve managing the dispute, resolving processes, ensuring fairness, applying the law, and ultimately delivering the binding decision. The arbitrator's primary responsibility is to ensure that both parties receive a fair hearing and that the process is conducted according to the agreed upon rules and the principles. The arbitrator's independence and impartiality are crucial to maintaining the credibility of the arbitration process, and this determines the acceptability of the award or the conclusion that is made at the end of the arbitral process. So let's look at the legal framework and the enforceability And this, I say, this will be discussed, particularly looking at the Ugandan law, because I'm Ugandan and I'm discussing this. I'm not going to do this in relation to other countries, but this is according to Ugandan law. So other countries may have different legal frameworks and the enforceability could be different, but this is particularly for the case in Uganda. So in Uganda, arbitration is governed primarily by the Arbitration and Conciliation Act. This is Cap 4 of the laws of Uganda, which provide the legal framework for both domestic and international arbitration. So it is enforceable in Uganda. So the Arbitration and the Conciliation Act, this act regulates the processes of arbitration in Uganda, providing for conduct of both domestic and international arbitration. It is based on the United Nations. Sorry for that. It's based on the United Nations Commission on International Trade Law, model law, which is a model law on international commercial arbitration, and incorporates the international best practices. So it is a law which is enforceable in Uganda, and it is also made in relation to the United Nations Commission Commission on International Trade. So it is even internationally enforceable. So the awards, the decisions which are made by an arbitrator in Uganda, if an arbitration takes place, if the seat of arbitration, if the seat of the court is in Uganda, then whatever is made here can be enforceable even internationally, because Uganda is a signatory. So we have the law, it is enforceable in Uganda, it can be enforced elsewhere in the world depending on the jurisdiction of a particular country. That is something which we need to take note of. So we look at the domestic arbitration. So once the arbitrator issues an award, it is final and binding on the parties, and the losing party must comply with the decision. If the party does not comply voluntarily, the award can be enforced by the courts of law. And if it is an international arbitration, Uganda is a signatory to the New York Convention of the Recognition of Enforcement of Foreign Arbitral Awards, which was made in 1958, which means that Uganda courts recognize and enforce foreign arbitral awards subject to certain conditions. So this ensures that an arbitral award made in another country can be enforced in Uganda, provided it meets the criteria established under the convention. Like I said before, that these awards can only be enforced if they meet some particular criteria, like specifically some legal procedures. They must be made within the law. So if they are outlawed, they cannot be enforced. But if they are made within the law, then they can be enforceable. So the enforcement process. To enforce an arbitral award in Uganda, the party seeking enforcement must apply to High Court. So the court may refuse to enforce an award on limited ground, such as if it is contrary to the public policy. If the award is not final, or it was made in a jurisdiction where it was not, where there was no agreement to arbitrate. So all these conditions must be made for the award to be enforced. Setting aside awards. How can they be set aside? The Act also provides the limited ground for setting aside an arbitral award, such as lack of jurisdiction, improper procedure, or issues of fairness. If there was no fairness during the process of arbitration, then that cannot be enforced. It cannot be enforceable because there should be fair hearing. Everybody, every party in the dispute must be given a right to be listened to, present their case well, to enable the arbitrator to make a fair judgment. So in the cases where there was unfairness, possibly where there was bias and one party was favored and the other wasn't favored, then that could be a ground for declining to enforce the arbitral award. We look at the limited intervention. So the court's role in arbitration is generally supportive, helping with the enforcement of awards and appointment of the arbitrators in cases where it is enforced. In cases where it is mandatory. But in most cases, the disputing parties are given a chance to appoint their arbitrators. But where a court gives you an arbitrator, then it could be responsibility of the court where need be. So courts may intervene in matters related to recognition and enforcement of arbitration agreements or awards, but the aim is to limit interference with the arbitration process itself, because this is something which is supposed to be done with an arbitrator with the disputing parties for the reasons we have given earlier on. So in conclusion, arbitration in Uganda is a well-regulated process, and both domestic and international awards are enforceable in the country, making it a reliable means for dispute resolution. However, the enforcement of an arbitration award depends on the adherence to procedural requirements and the grounds upon which court might set aside the award, and this has been discussed clearly. So this is a very good approach where court case backlogs can be actually reduced. If people can appreciate this and they appreciate the alternative dispute resolution mechanisms, instead of getting into court, you spend 3-4 years chasing lawyers, chasing out judges. It wastes a lot of time. People sometimes suffer a lot in the courts of law and they don't find justice. So an easy way to get justice is actually to embrace ADR. It's a very good practice. The good thing, it is enforceable in the framework, the legal frameworks of the country of Uganda. That's why I appeal to people who have cases in court. They have been there for months, for years. They can actually choose to go for ADR mechanisms and get their cases resolved. People are remanded in courts for years. They have never been presented to court. They have never given date to go for hearing. Yet they have minor issues which can be actually resolved. So I encourage people who are actually listening and watching this that it is better and it is high time we embraced ADR as a means of resolving some of the disputes we have, that can save a lot of our time and a lot of money that we waste in court. So the framework encourages businesses to use arbitration as an effective alternative to litigation, especially for resolving commercial disputes, maintaining business relationship, and ensuring enforceability across borders. So this brings us to the end of my presentation today. I believe somebody has picked something to learn. You can go ahead to read more about arbitration. Below there on the timeline are my numbers and my email, just in case you want to reach out to me, and just in case you have a dispute that you want to be assisted to resolve, you can also reach out to me. I can help you resolve such matters instead of getting in litigation in court. This we can solve in a short time and we save a lot of money. Thank you for listening. Geoffrey Mtala is my name. I'll be glad to hear from you, and I'm happy that we have had this good time with you. Bye for now. Let's meet next time.